This is the Dollemore Daily, and I'm Jesse Dollemore. As predicted, there is a little bit of a bump in the road relative to the release of the hundreds of pages of documents that Donald Trump absolutely does not want released related to the insurrection on January 6th. The secret documents, the until now not seen, that will reveal exactly why Donald Trump doesn't want them public, doesn't want them seen by investigators. We'll just start there. That will give us an insight into the goings-on of the White House, how much involvement they had in the planning and the execution of the Stop the Steal rally and the subsequent attempted overthrow of the United States government. The assault, the attack, the domestic terror campaign against the United States government and the U.S. Capitol. The attempted overturning of a free and fair American election that was settled. Joe Biden won by millions of votes. 7 million votes. And an appeals court has blocked temporarily the release of those records until they can make a ruling on the case. I'm going to read from this Washington Post article. Appeals court temporarily bars release of Trump White House records to House January 6th committee. A federal appeals court on Thursday blocked the imminent release of records of President Donald Trump's White House calls and activities related to the January 6th Capitol attack after a lower court found that President Biden can waive his predecessor's claim to executive privilege, a privilege that Donald Trump does not possess or enjoy. Again, executive privilege exists as another facet of separation of power, of checks and balances. And Donald Trump isn't a part of the federal government any longer. There is no need for him to have executive privilege to buttress against an overzealous Congress. He's not the president. There is no give and take. There is no push and pull. He's an ex-president. The U.S. Court of Appeals for the D.C. Circuit granted a temporary injunction while it considers Trump's request to hold off any release pending appeal, and fast-tracked oral arguments for a hearing November 30th. I don't know about fast-tracked, everybody. It's quite a while away, quite a ways away. 18 days. And that is what we're up against here, the clock. Because Donald Trump, this is a concerted effort, an organized movement to slow the pace of the committee's investigation, hoping to push it past the midterms, and then hoping that Republicans take back control of Congress, because then the committee will go away. The order came after U.S. District Judge Tanya Chutkan of Washington on Tuesday cleared the way for a handover of documents to a House investigative committee, ruling that an ex-president, there we go, Washington Post, there we go, ruling that an ex-president's claim to residual right to withhold records from Congress after leaving office does not continue in perpetuity. Presidents are not kings, and plaintiff is not president, Chutkan wrote. In a 15-page emergency motion filed Thursday, Trump's attorneys, and I want to talk about this argument because really it cuts right to the heart of what I'm talking about and have been talking about for months now. In a 15-page emergency motion filed Thursday, Trump's attorneys asked to keep the documents secret for now and proposed that all sides brief the court next week on whether to keep them so for the weeks or months an appeal may take to decide. Again, slowing the process. Trump's legal team said the case presented serious, novel questions about whether a former president can sue a successor to withhold government records from Congress, and that the institution of the presidency would be irreparably harmed if the documents were released beginning at 6 p.m. Friday as planned. Quote, the disagreement between an incumbent president and his predecessor from a rival political party highlights the importance of executive privilege and the ability of presidents and their advisors to reliably make and receive full and frank advice without concern that communications will be publicly released to meet a political objective, Trump attorney Jesse Banal wrote. Dum-dum attorney, colleague of Sidney Powell, attorney for traitor Michael Flynn. Jesse Banal. That is nonsense. Again, Donald Trump is not in the government. There is no need for separation of power. He has no power. All he has is his dumb website, DonaldJTrump.com, to issue his stupid statements that we on this channel, and by we, I mean me, make fun of on an almost weekly basis. The appeals court acted one day after Chutkan rejected a similar emergency motion, writing that the legal question was not a close call and that she would not effectively ignore her own reasoning in denying injunctive relief in the first place to grant injunctive relief now. Capping days of legal drama, the appeals court rocketed consideration of the case through federal courts in Washington. While granting an injunction pending further order, the court set a schedule that signaled it would act swiftly to decide whether to withhold records while an appeal is pending. If it declines, the documents will be released, effectively mooting the case in a victory for the House. Now, no matter how this goes, it is destined for the Supreme Court. And I don't see any other way that they can rule because of the separation of powers issue, but for the Congress, but for the continuation of the investigation into the events of January 6th, violent, attempted, yet failed coup. Trump could still appeal to the Supreme Court, and a ruling keeping records secret could work to his advantage if litigation is prolonged through the 2022 midterm elections, when Republicans hope to take the majority in what is now a Democratic-led Congress. Slim majority in both houses. In her ruling Tuesday, Chutkan said Trump failed to identify an injury to privacy, property, or otherwise that he will personally suffer from the production of records. As for the presidency, the judge quoted a landmark 1977 Supreme Court ruling saying that executive privilege serves the republic, not any individual. This is something I've been hammering on about for a couple months now, that executive privilege doesn't follow the prior occupant of the office. It is for the institution of the presidency, not the president himself or herself. It is to protect the integrity and the ability to govern, and it's misused by about every president, but of the office of the presidency. There's a difference there. That is why people show deference to each individual member of the office, because it's like a judge. You're showing deference to the court and to justice, not to the man or woman who sits on the bench. Same thing with in the military ranks. That is why certain things, I'm really kind of going far afield here, but like a Medal of Honor recipient, a general has to salute a not the private who has been awarded the Medal of Honor, but you're saluting the medal, not the person. It's a similar ilk. I'm just trying to give all these different explanations so some people can understand it. Let's get back to this article. Chutkan noted that former presidents waived executive privilege when dealing with matters of grave national importance, including the Watergate break-in of Democratic National Headquarters by Richard Nixon's 1972 re-election campaign, the arms for hostages Iran-Contra affair under Ronald Reagan, and the 9/11 terrorist attacks on New York City and the Pentagon during George W. Bush's presidency. Quote, the incumbent president, not a former president, is the best positioned to evaluate the long-term interests of the executive branch and to balance the benefits of disclosure against any effect on the ability of future executive branch advisors to provide full and frank advice, Chutkan said. And that sums it up. That absolutely sums it up. My prediction is this is going to go the right way, the correct way. But it's going to take a little time because, unfortunately, politics are allowed to be politics, and the swiftness of justice isn't always as swift as we would like. What do you think, though? I'd love to know. You can call. Leave me a brief voicemail, 714-576-4054. Of course, you can email me daily at dollemore.com. why don't you do me a favor and follow me on Twitter or Instagram or TikTok, if TikTok's your thing. It's barely my thing, let me be honest. I'm at Dollemore, Dollemore, just about everywhere. And the other thing is, if you are feeling in the spirit and you want to support my work, if I bring you enough value that you would give me of your precious attention and your treasure, I would appreciate you helping support my work, helping produce my work. You can click the join button below this video, see what's involved in becoming a channel member, and for as little as $1.99 a month, you can become a channel member, helping produce what I do here. Or you can become a patron by going to patreon.com/IDoubtIt podcast. Not just for the podcast, also for YouTube. I love you guys. I appreciate it very much. We are in the process of growing this into something substantial and different and varied, and I am excited about it. In the coming months, my wife and I are moving to Washington, D.C. to be a little closer to the action, to be able to interview people who are gathering there to protest, whatever, and to interview members of Congress to be closer to the center of government and the topics that we talk about on a daily basis. So your support would greatly assist in that effort as well. I love you guys. I will see you next time. Until I do, be genuine. Take care of one another.